And just to let you know, there's a temporary delay. We will be starting shortly. Thank you. Thank you. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon, everybody, and welcome to your North Carolina Court of Appeals. I am Judge Lucy Inman, and presiding with me this afternoon, on my right, Judge Valerie Zachary, and on my left, Judge Allegra Collins. We have one matter on the calendar this afternoon. That's Bill Clark Homes of Raleigh versus Town of Fuquay Varina, Court of Appeals docket number COA 21-79. Are counsel ready to proceed? We have, I think the timer is, just before we start taking up your time, the timer is set for 5 minutes of rebuttal. Do you want more than 5 minutes or less than 5 minutes of rebuttal?
I'm going to ask to reserve 10 minutes of rebuttal.
10 minutes of rebuttal. Just a moment while I look like I'm the master of technology. Someone else in this room is setting that. Our clerk, Jean Soar. Thank you very much. And when you start going into your 10 minutes, the yellow light will come on.
Thank you, Judge Inman.
Sure.
May it please the court, my name is Chris Edwards, and I'm here with my co-counsel, Jordan Spanner. We represent Bill Clark Homes of Raleigh, LLC, the appellant in this matter. In 2016, Bill Clark Homes paid $195,500 to the town of Fuquay pursuant to the town's capacity fee ordinance. That ordinance, section 5-1016, provides that it is to build capital reserve funds for future investment in water and sewer services.
May I go ahead and ask you a question, even though you just started?
Yes, Judge Zachary.
Was payment of that capacity fee a condition of the plat approval?
It was a condition of the plat approval.
Okay, and then do you know how the town calculated the capacity fee?
It was calculated on a per dwelling unit basis. I believe that that is reflected as attachment A to our complaint on page 12 of the record, which shows that the fees for 46 homes for water is $1,500 a home, and for sewer it's $2,750.
Right, and I saw that, but the question that I still had was how much of that is for past cost and how much of it is for future expansion costs?
I understand that concern, Judge Zachary. We're here, though, on a motion to dismiss, so viewing the facts in the light most favorable to Bill Clark Holmes, as the court should on review of a motion to dismiss, I think it is safe to assume that all of that was for potential future expansion of the water and sewer services.
Is there any evidence in the record to indicate what it was for?
No, Your Honor, there is not.
Except the ordinance?
Except other than the ordinance, which indicates that it could be for either past expansion or future potential expansion. And again, reviewing the evidence or reviewing the record in the light most favorable to Bill Clark Holmes as the non-movement below, it would follow that all of those fees were for future expansion.
Of course. And then is there any evidence in the record about what the future cost was slated for? So, for example, was it slated for, future costs for expansion, or was it slated for, to serve new customers, or was it slated for future maintenance and repair?
Your Honor, I don't believe there is any evidence in the record concerning what those future costs were for. I think there are several ways to look at the answer to that question. I think that the town would say that those future costs were for the expansion related to the Sunset Lake Road waterline expansion. But even so, the development agreement between the parties is unambiguous that they were paid pursuant to the ordinance. The development agreement says, Bill Clark Holmes, you are paying all applicable fees, including capacity fees, set by the town's code of ordinances. So that's one way to look at it. Another is, I don't believe that it's actually relevant how the fees were used in the future under our Supreme Court's decision in Quality Built Homes against Town of Carthage. The court in that case talks about it simply being unlawful under 160A 314 to charge fees for future water and sewer services. So applying Quality Built Homes to those facts, I don't know that it matters, but I guess that's a long-winded answer to your question, that no, there is no evidence in the record about how they're used.
Okay, thank you. And again, I apologize for interrupting you so quickly.
That's not a problem. I think that is actually the very first point that I was going to make about why reversal is appropriate. So first, Bill Clark Holmes did pay water and sewer capacity fees pursuant to the ordinance, and that's expressed from the language of the development agreement. Second, there is no other statute that would authorize the town to collect these fees, at least in the way the development agreement is structured. And finally, the claim is timely under our Supreme Court's second Quality Built Homes decision. So building on that first point, Judge Zachary, about what the payments are for and how they were paid or why they were paid to the town, other provisions of the development agreement actually explain that Bill Clark Holmes was paying capacity fees and not paying, as the town contends and as the trial court determined, fees associated with the expansion for the Sunset Lake Road waterline expansion project. And that's found in two places. So first is Section 3 of the development agreement. In Section 3, in Romanet 1 and Romanet 2, the town very explicitly has agreed that it will bear the entire cost of all necessary construction. So, and I feel a little bit like I'm shadowboxing against the town's argument, but the line of thought goes, you agreed to pay these fees, we put them in our capital reserve funds and immediately expended them. So that's okay. And Again, we have a problem with that under quality-built homes, but in any event, I think that the language of the development agreement shows that the town actually agreed to take up the sole responsibility for funding this project. And we know that if the parties had wanted Bill Clark Homes to fund any portion of the expansion, they knew how to do that. Looking at Section 1I under developer obligations, it's very clear that the developer is responsible for acquiring the survey necessary to expand the water line. Bill Clark Homes expressly agreed to pay for that. Likewise, it agreed to pay for all of the needed permits by the town to actually expand the water and sewer line under Section 1I. So again, we have a development agreement that references the town's capacity fee ordinance 5-1016. That ordinance plainly violates quality-built homes, and the town does not contend otherwise. It's our view that the town has waived that argument under Appellate Rule 28B6 because it has not briefed. It has never contended, even at the trial court, that its ordinance was otherwise lawful. So we have a provision requiring payment of fees under an otherwise unlawful provision, and then we have two additional provisions confirming that the town is going to pay the expenses necessary for construction, and showing that Bill Clark Homes, when it did agree to pay for something, had the parties expressly indicated that Bill Clark Homes would be responsible for payment.
I just want to make sure that we're on the same page, that we've got this ordinance, part of which talks about past expenses and part of which is future. So it is your contention that part of that ordinance under quality-built homes is impermissible, correct?
Yes, Your Honor, and when I'm speaking about the ordinance being unlawful, I'm only saying, assuming that the facts are as we say they are, viewing the facts in the light most favorable to Bill Clark Homes, I think should the court reverse the trial court's determination on the motion to dismiss, I do believe that the past and future dichotomy would be subject to discovery. I don't know that that would.
But I just want to make sure that is your contention that it's only the portion of that
That's
ordinance
correct.
that's talking about future that under quality-built homes would not be permissible, correct?
That's correct. The past expansion, we have not raised an argument about that, and our argument is solely based on the future potential expansion under
Okay.
quality-built homes.
And I want to ask another question. So am I correct that on 7 October 2014, y'all entered into the agreement,
That's
correct? And then this payment was made February 4th, 2016, correct?
That's correct.
Okay, so what happened in the middle between those two as far as construction? Where were we at the point that this payment was made on February 4th? Had everything been built?
I don't believe that's clear from the record, and I've only handled the case, I handled the argument in the trial court, but I actually do not know where the construction was. And I know that's an unsatisfactory answer, but I don't know, and it's not in the record.
Because this says that within 9 months of signing the agreement, certain things were to happen, and then within 12 months of signing the agreement, certain things were to happen.
That's correct. That's correct.
Okay.
Just not to fit too fine a point on Judge Collins' question, your client's suing for $195,000 and change.
That's correct.
But if discovery were, if this panel were to agree with you in reverse, and the case proceeded in discovery, and discovery bore out that, say, $185,000 was for past expenses, would you agree that that would not be recoverable?
I would agree that that would not be recoverable under quality-built homes, Your Honor. That's correct.
Okay.
The entire premise of the lawsuit is that a portion of the ordinance does indicate that there's the opportunity for future use. And viewing the facts in the light most favorable to Bill Clark Homes, I think the court should at least assume that that was how the fees were applied.
Okay, thank you.
Except for the fact that when we look at this agreement, that things had to happen 9 months and 12 months after the agreement, which is well before this payment was made. So looking at the facts based on the agreement itself, all of the construction was completed per the agreement even a year before this payment was made. Doesn't the agreement say that certain things have to be done 9 months and then 12 months and then it's done?
That is what Romanet 1 and Romanet 2 say in Section 3, but if you read Section 3 in its entirety, it indicates that construction will not begin until the fees are. So the agreement is, I believe, ambiguous in that regard, because it does require that Bill Clark Homes pay all applicable fees before the town will commence construction. And so it's unclear what the status of the construction was, and then, again, yes, it does say that, but it also says that the town's not going to begin construction until the capacity fees are paid, and as you've noted, that didn't occur until February 2016.
But looking at the pleadings, which we must at this stage, there's nothing in the pleadings, there's nothing in any of the pleadings that establishes how that money was spent.
No, Your Honor, there is not. Again, that would be the subject of discovery on remand.
Okay.
I want to address, well, let me ask first before I move on, does the court have any other questions about the ordinance? I want to make sure that I give every opportunity to address that, since it seems to be of interest to the panel.
And and Quality Built Homes came out well after you all had signed this agreement and paid this, correct?
It did, Your Honor, that's correct. But again, in the second Quality Built Homes case, our Supreme Court determined that the statute of limitations on that was 3 years, and the payments weren't made until until February of 2016. I don't believe it's in the record. I don't understand defendant to be arguing this on appeal, but the parties did have a tolling agreement in place. And so pursuant to that tolling agreement, the claim would be timely.
Doesn't this seem like a bit of a windfall to come back 3 years later and say, gosh, even though we agreed to pay this $195,000 and we got the benefit of our bargain, but now we want our money back?
I don't believe it is a windfall, Judge Collins, and that's because the town lacked the authority to do this. And as you know, we're a Dillon's Rule state, and so it's not a windfall to allow Bill Clark Homes to recover from a fee that was unlawfully exacted from it in the first place. The town does not have, or did not have, under 160A.314, the authority to charge for services to be furnished. And here that's exactly what the town did, at least viewing the facts in the light most favorable to Bill Clark Homes. So no, I don't believe it's a windfall.
Although it was bargained upon, correct? That it was understood that these fees would be charged and paid for as part of the entire agreement, correct? And y'all didn't have any idea that you couldn't do this until 3 years later.
Well, the fees would have been necessary regardless of whether the agreement was in place. If you look at the agreement more broadly, sort of from a contextual angle, I think it really provides the background of what the parties were trying to get at here. The agreement contains specific language, both in the whereas clauses, I believe it's on page 16 and 17 of the record, and then on page, I believe, 17 and 18 of the record, indicating that the bargain between the parties is Bill Clark Homes had agreed to build homes with a certain average value of $350,000. The town agreed, thinking this sounds like a good deal, to extend its water and sewer system, and it would then annex the Sunset Glen development. So the quid pro quo, if you will, is more or less Bill Clark Homes agrees to build nice single-family homes, and the town agrees to take it in for the increased tax benefit. The agreement to pay applicable fees, again, those fees would have been owed regardless of whether this development agreement was in place. And in addition, I think it's important that the language used was applicable fees. None of the statutes that the town has cited in its appellee's brief, including 160A 400.20, 160A 320, none of those give the town the authority to charge an otherwise unlawful fee. So it would be our contention that it's not an applicable fee. We did agree to pay the fees that could be lawfully imposed, but the statute 160A 314, our Supreme Court has determined that it unambiguously does not allow the town to charge for services to be furnished. So I don't agree that we agreed to pay these fees. We agreed to pay applicable fees, but again, in the larger context of the agreement between the parties, this was sort of a side deal, and the real bargain there was for an increased tax base for the town.
So did you negotiate the applicable fees, or did you negotiate other terms of the development agreement?
I do not know the answer to that, Judge Zachary. That's not alleged anywhere in the complaint. I believe, again, that would be a question for discovery. I would say that the applicable fees language, at least on its face, indicates that the parties agreed that Bill Clark Holmes would pay the fees required by the town's code of ordinances, the fees that any other developer would be required, whether they were in the town, out of the town, in the town's expansion district, opportunity zone. I don't remember the exact language as to why the town could legislate in this area, because it was not in the town at the time. But the point is, the agreement was to pay the fees that the town would impose on anyone else, as I understand it, and that does not include fees for services to be furnished under 160A 314.
But at the time you entered into the agreement, it did include that because Quality Built Homes wasn't out. So I would assume someone would sit down and determine how much per house this was going to cost and understand that $195,000 was going to be paid at the time that you entered the agreement.
That's correct, and I think that goes to one of the town's primary arguments, which is this idea that the funds were paid into the town's treasury, and then they were immediately used to build this expansion. And this therefore, is kind of the practical side of the transaction. But again, both parties agree that the contract should be interpreted pursuant to its four corners, and the language of the contract here specifically references applicable fees required by the town's code of ordinances, and the town's code of ordinances specifically requires fees for services to be furnished. And so, regardless of what the parties agreed on at the time the contract was signed, the point is that the town does not have the authority to enter into an illegal or ultra vires contract. Under section 160A 400.20 subsection B, the provision specifically authorizing development agreements, it actually says this does not give you, cities, towns, municipalities, the authority to negotiate for a tax or a fee that you could not otherwise impose. And so if the town were to have negotiated the agreement with the understanding these fees for future services would be applied in this way, that would make it unlawful under 400.20 sub B. In my final moments, I want to address the town's statute of limitations argument. The town contends that this case is controlled by a one-year statute of limitations. It raises this as an alternative basis for affirmance. It raised it in the trial court as well, and the trial court didn't address it. Our Supreme Court in 2018, in Quality Built Homes, it determined that claims under 160A 314 are claims for violation of a state statute. Those claims are subject to the statute of limitations set out in 152 sub 2, which is a 3-year statute of limitations. That 3-year statute of limitations clearly applies here, and the town's contrary argument is without merit. If the panel has no further questions, I will yield the remainder of my time and save the rest.
I have
Yes,
one
Judge
question. I
Fallon.
think there was some disagreement about whether a contract required repayment for funds expended or allowed repayment for funds expended. I think it was,
Is that section 160A 320?
could be.
That's the one with the $250,000 allotment.
Yes.
I actually think, as I went back and reflected on the briefs, I think that's a little bit of a red herring. I don't know that it applies here. If you read the text of that statute, it says that towns can basically do small jobs without bidding them publicly. I direct you to page 25 and 26 of the record, which is the section of the development agreement that actually references section 320. The very last sentence on page 26 under section 18 says the town will publicly bid the SSLR water line extension and pump station and force main work. I would take that, I understand that to mean that the town was not evaluating the actual the town was not evaluating the actual expansion of the water line system. The only thing the town was on the hook for then that it didn't need to publicly bid out was the option to carry sewage if it didn't timely complete the construction. I see that I'm into my rebuttal time. If the panel has no further questions, I will yield. Thank you.
Good afternoon, Your Honors. Dan Hartzog Jr. from Hartzog Law Group on behalf of the Town of Fuquay Varina. With me is my co-counsel, Katie Barber Jones. Your Honor, this case stems from a development agreement, which is essentially what happened is that the plaintiff represents a developer. They wanted to come in and build a large subdivision that the Town of Fuquay Varina did not provide water sewer services to. It was going to require substantial costs, substantial amount of monies to be expended in order to allow that subdivision to connect to the town system. The town had no plans to provide water sewer services to that area, and so when the developer came in and said, we're going to build this, the town said, okay, let's work together on an agreement, which we are allowed to do by statute, and try to find a way that we can have a mutually beneficial arrangement here where the town will extend our water sewer services we had no plans to do to your development, and then you can tie in, and we'll write all this up in an agreement that we'll both be bound by. Both sides had attorneys looking at it, drafting it. It was mutually drafted. That says that in the agreement. And they decided, okay, we're going to pay these fees. That was one of the obligations of the developer. And in exchange for that and other things that the developer agreed to do, the town agreed to extend the water sewer services. So, Your Honors, if you look at the actual agreement, when you look at the obligations of the town and the developers, Section BF, one of the things that the developer said, we agree to do this in exchange for receiving water sewer services. We agree to pay all applicable development fees, including capacity fees, recreation unit fees, and other applicable fees as prescribed by the town's code of ordinances and by the fee schedule. So, one, I don't know how the developer could come in and say, well, those aren't applicable fees, because it says right there, applicable fees, including capacity fees set forth in the fee schedule at the time of the agreement.
Would you concede that under quality built homes, the portion of the ordinance that allows for payment of fees for future expansion is not permissible?
I would concede that, Your Honor.
Okay.
Yes.
So is it your argument then that the fees that were applicable in this case were paid for expansion that was already built?
It is in exchange for the town's obligations. It's a simple contract. You agree to do this, and in exchange for that, I agree to do this.
Is it your position then that the parties could contract around the rule of quality homes?
The rule of quality homes is that you cannot charge for future services. And if we had included a provision in our agreement that says you agree to pay $500 for future services, future water sewer services, then I think that this would be a different case.
But didn't you do just that by saying you need all applicable ordinances? And if you have an ordinance that includes future, haven't you then included future cost in your fee, your capacity
No, Your Honor,
fee?
because the payment of the fee was not pursuant to the ordinance. It was pursuant to the development agreement. It was one of the bargained for things in the development agreement. You pay this fee that's set forth in our fee schedule, and in exchange for that, we will provide water sewer expansion, we'll build the pipe, we'll do all this other stuff. That is what plaintiff received in exchange for the payment of these fees.
So you're saying that the development agreement does not refer to ordinances?
It refers to ordinances, but we did not charge them the fee pursuant to the ordinance. And that is a distinction that is important in this case. We charged them the fee pursuant to this development agreement in which they agreed to pay the fee. It was not imposed on them. They said, yes, we agree. We will pay this fee in exchange for your obligations under the development agreement.
So the fact that the development agreement refers to ordinances doesn't mean that it's being charged pursuant to the ordinances?
Correct, Your Honor. Because when you're looking at a contract, you're looking at what does each party get from the contract. Plaintiff says, I'm going to pay these fees, and in exchange for that, you're going to expand your water sewer system. That is not future services. That is services rendered. They got what they bargained for. So this is not a quality-built homes case. This is, sorry.
Excuse me, that brings me to the question that I asked of your colleague, which is, you know, how did the town calculate the capacity fees?
We have a fee schedule. They had a fee schedule.
Well, I know it's per residence, but I mean, how much of that was for past and how much of that was for future?
Well, in this case, none of it was for future.
Is there any evidence of that in the record?
Yes, the contract, because it was a bargain for you pay this, and in exchange for this, once you pay this, you get this in exchange. And what was, if you look at the town's obligations under the agreement, it doesn't say in exchange for the capacity fee, we're going to put this towards future services. It says in exchange for you paying these capacity fees, we're going to, within 9 months, we're going to build this 8-inch diameter water line. We're going to put this sewage pump in place. We're going to provide these services to your development in exchange for your obligations under the contract. Had we not had that in the contract, the town probably would have exercised its right to do a special assessment, which is something we mentioned in the brief. That you know, plaintiff was arguing, oh, this is not a public purpose, this expansion of water sewer services, which of course it is. And we pointed to the statute, 160A 216, which says that we can assess the plaintiff for expansion, construction, extending water sewer systems to their development. We didn't do that. I agree with the plaintiff that we didn't go through that process because we had this agreement in place with the plaintiff that they were going to pay these fees. That was a bargain for exchange between the two parties.
So were the capacity fees that you charge, I'm looking at in the record, page 12, were those fees different than what you charge everyone else?
Yes, because the fees charged to everyone else were charged pursuant to an ordinance.
Okay, so right here it says water fees, you know, 46 fees per $1,500. So how much would it have been otherwise?
The amount, I believe, would have been the same.
The $1,500 per unit.
Right. The amount of the fee, I will concede, would
Okay.
probably be the same as charged to everyone else.
And the sewer fee is $27.50 per unit, and that's what you charge everybody.
I believe that's correct, Your Honor. But the key issue is the purpose of those fees. What are they used for future services, or are they used for services rendered? And here, plaintiff's argument, I suppose, is, well, we don't know how they used the fees or what they were going to be for. Well, we do, because it's a bargain for exchange. It's a contract. And the town says we will expand this on the condition that you pay these fees. So they are receiving in exchange for that payment immediate services.
Depending on which of these competing arguments this panel is persuaded by, just assuming for the sake of argument that this panel agreed with the appellants and reversed and remanded this matter, and it went to discovery. And I know that's no small feat. But it went to discovery, and discovery bore out everything discovery bore out that all these fees were paid for past work. I believe Mr. Edwards has conceded that his client would not be entitled to recover fees that were paid for past work. I may have misunderstood him. He'll let me know on rebuttal.
That's what I heard as well.
He qualified it by saying subject to quality homes. So other than, and I know it's no small thing, the cost of discovery, what's the harm of this case going back and going through discovery rather than having this bright line rule? What you're arguing is we have an agreement and you need to interpret it in this particular way so that this town doesn't have to go through litigation.
Your Honor, I'm not going to stand up here and say that, the burden of discovery is too much for us and you can't put us through that or anything like that. What I will say is that the proper inquiry for this court is whether the trial court erred in determining that this was that these were paid pursuant to the contract. And what the contract says, again, Your Honor, is you don't need to do any interpretation of the contract. You just need to say, well, they said they'd pay this, and in exchange for that, they got this. All you need to do is look at the obligations under the contract, and you can see very easily that this was not some payment for future services. This was payment, it was a bargain for exchange for specific things set forth in the contract that both parties negotiated for and both parties agreed to do. And here we are, 3-4 years later, and the plaintiff is saying, well, yeah, we did agree to that. We bargained for this, and we knew that we would pay this in exchange for getting this, but we've since decided that you didn't have the right to do that. Yes, we agreed to it. Yes, we got what we bargained for, but we want our money back anyway. And that's really what this case is. It is a windfall. They got what they bargained for from the town. Had the town not been able to charge these fees, again, we could have done other options. We could have done a special assessment. We could have declined to extend the water sewer services.
And this was pre-Quality Homes.
It was.
So if you could have seen into the future that Quality Homes was going to happen, I imagine there are a lot of agreements that might have been written differently and a lot of towns that might have done things differently.
The agreement may have been worded a little differently, but I think the effect of the agreement would have been exactly the same. That you pay these fees, you pay this amount of money, and in exchange for that, we will extend the water and sewer services.
Can I ask you a question? So
Yes.
while an ordinance can't require a party to pay a fee for future services, do you think that the town and a builder can contract together for the builder to put money into a pot to be used for future development?
I think that is a very good question, and I'm not sure the answer. I believe the answer is likely that you cannot do that because of quality built homes. But again, that's not what was done here.
If it was not pursuant to an ordinance, could they just say, we're going to pay $200,000 for things that will be built, that were built, and then $200,000 to continue that sewer service into the future, not pursuant to any ordinance?
Well, Your Honors, if you look at the contract, if you look at the statutes that apply, arguably you could. That's not the issue before the court today, but arguably you could. Under 160A 320, the town has a right to contract with the developer for public enterprise improvements. Under 160A 312, we have the right to contract for the construction, establishment, improvement, maintenance of water sewer systems. And what Quality Built was examining was, do you have the right under the public enterprise statutes to charge these fees? And the specific language of the public enterprise statute is what controlled in Quality Built.
Right.
Because in the public enterprise statutes, it says you can charge for services furnished. That's distinguished from other statutes that say services to be furnished. So again, if we were charging just without an agreement, just enforcing our ordinance against them, we would be relying on the public enterprise statutes. We're not relying on the public enterprise statutes. We're relying on our statutes that say you're allowed to contract for these things. That is a different arena than Quality Built was examining. Quality Built hinged on that particular phrase in the public enterprise statutes. Again, we're not dealing with the public enterprise statutes here. We're dealing with 160A 320. We're dealing with 160A 312, which allow us to contract for maintenance, improvement, enlargement, operation, public enterprises, contract for improvements. So under those statutes, I think the analysis is entirely different than Quality Built Homes. And because we're in the contract arena rather than the enforcement of an ordinance arena, the analysis in Quality Built really doesn't apply because that was specific to the public enterprise statute language. Here we've got other statutes that we're dealing with that do give us broader authority to contract for those types of things.
Well, in negotiating with the town, what leverage do the developers have?
Well, they have the leverage of, we're bringing in, you know, a large community, large potential tax base. They have some leverage in the fact that they're coming and bringing something that the town is going to benefit from. But again, if you look at the agreement here, we're not really concerned about leverage, who has the most leverage, because if you look at section 16 of the agreement, it says the parties have sought and received advice of their respective legal counsel. It was mutually drafted by everyone. So we're not in a situation where the town, you know, exercised some, you know, leverage against the developer and the developer had no choice. This was, as written in the agreement, a bargain for, mutually drafted agreement that both sides said, yes, we agree to these terms. We're happy with what we're getting in exchange for what we're agreeing to do. And the town did what they agreed to do, the developer did what they agreed to do, and everything was good until the developer said, you know what, I'd like that $190,000 back. Because they believe that Quality Built Homes controls, which it does not, because we didn't charge it pursuant to the Public Enterprise Statute. I'd also like to address the argument of the statute of limitations in Quality Built Homes. Quality Built Homes 2, as has been argued by plaintiff's counsel, did say that they viewed the statute of limitations at that time as a 3-year statute of limitations. Subsequent to that decision, the legislature adopted a new statute, 160A-216, or I'm sorry, 160A 393.1, that said for development, for application of a development ordinance, it is a 1-year statute. And that was application whether you believed it was facially invalid, as applied, ultra vires. If you believe that a development ordinance, which is what this is, it's an ordinance that deals with development, is applied to you in an unconstitutional or illegal or ultra vires way, you have 1-year statute of limitations. That's the legislature stepping in after Quality Built Homes and putting a new statute out there. So Quality Built Homes 2 was analyzing different statutes. They did not have the ability to address 160A 393.1 because it didn't exist yet. It was put into place in June of 2019 and applied to this case, which was filed in August of 2019. And in addition, they said that it was retroactive. They were clarifying that this is the statute of limitations for challenging a development ordinance or application, whether it's on its face illegal or whether it's illegal as applied. Both of which the plaintiff sort of has argued that it's illegal on its face and it's illegal as applied. Those claims now have a 1-year statute of limitations because that's what the legislature said.
Okay, and so just to be clear, 160A 393.1 was enacted before this lawsuit was brought, was enacted
Yes.
after the money was paid,
Correct, Your Honor.
and
but they
after Quality Homes,
said, correct, after both Quality Homes.
after both Quality Homes
Correct.
decision. And you said that it's retroactive because it says it's clarifying?
Yes. And we've set that forth in our brief with a little bit of the history of that.
Okay.
But it definitely applies, and if you read the statute, and plaintiff's argument as well, that's a zoning regulation, but that's not what it says, development ordinance. And I should point out, Your Honor, that it is now codified under 160D 1403.1. As Your Honors are well aware, the 160A development ordinances were rescinded and replaced by 160D. So that is now found under 160D 1403.1, but the language is the same, which says that claims involving questions of interpretation in lieu of any remedies available under the other statutes, if a decision is being challenged from an administrative official charged with enforcement of a local land development regulation, which is exactly what this is, land development regulation, the party has to bring it within 1 year. and that's whether the ordinance is on its face unconstitutional as applied, ultra vires, preempted by some other law, or otherwise in excess of statutory authority. So again, when Quality Built Homes 2, when the North Carolina Supreme Court was analyzing this type of claim in Quality Built Homes 2, it didn't have this statute. It was looking at the arguments in that case were there was a contract statute that they said applied, and the court said, well, it's not really a contract. And there was a challenge to the validity of an ordinance. And they said they're not really challenging the validity of the ordinance, they're challenging the way it was applied. Well, here, this is the validity of an ordinance or the way it's applied. So the analysis in Quality Built Homes 2 was only left with, well, I guess we default to the 3-year statute of limitations for liability pursuant to an ordinance statute. Here, we've got a much more narrowly focused statute, and under Fowler v. Valancourt, if there are 2 statute of limitations that potentially apply, you go with the one that is more specific. And this one is very clearly more specific. This is challenging a land development regulation, which is exactly what this is. And so the legislature is clear that this should be a statute of limitations of 1 year. Not to mention the fact, Your Honor, that even if it were a 3-year statute of limitations, that statute would have arisen when they signed the contract, because that's when they were bound to pay this fee. So upon signing the contract, that was it. They were required to pay that fee. So at that point, the statute of limitations begins to run, because they were aware that this fee was owed, and if they thought it was illegal, they could have brought that claim within 3 years. They did not. They did bring it within 3 years of paying the fee, but they did not bring it within 3 years of when they knew they were going to have to pay the fee. And that's the relevant statute of limitations. When you're aware that when you're obligated to pay the fee and you know you owe it and you believe it's illegal, you have, even if it's 3 years, they have missed that window.
So just so they understand, your argument is on the day that they entered into the contract was the day they should have brought the suit that says that it was illegal? Is that your argument?
If they believed that the fee that they were paying was illegal under the contract, then that claim arises once they sign the contract and they are obligated to pay that payment. Now, of course, as a practical matter, Quality Built Homes hadn't come out yet, so no one would have thought that this fee was illegal at the time, but that's not really the correct analysis. The correct analysis is when does the claim arise? The claim arises when the fee is owed. And that is, we've cited a case, and we have submitted as additional authority this afternoon prior to the argument. Epcon v. Town of Chapel Hill held exactly that once you know you owe the fee, your cause of action arises.
That's a federal case.
It is a federal case,
Okay.
but it's analogous. Let me just check my notes here. Right, so, and again, we don't agree that we applied the ordinance to them, but to the extent we did, the statute of limitations, either the 1 year or the 3 year, beginning on that date, would apply.
So that's an independent basis that you would argue for this court to affirm.
Correct, Your Honor.
And it doesn't matter that the trial court didn't address the statute of limitations?
We argued the statute of limitations, but it wasn't addressed by the court because they found that this was a valid fee pursuant to the development agreement.
Right.
Which we agree is correct and should be the result of this court as well. To the extent this court believes the fee was a violation of Quality Built Homes, then in that event, you take plaintiff's argument as true that we were applying the ordinance to them. And if that's the argument, then this 1 year statute of limitations under 160A 393.1 applies.
Okay.
But our position is this is a bargain for agreement, not some fee that we charge them that they were required to pay for future services. This is a fee that they bargained for in exchange for what they got under the contract.
And just just from my understanding, to assess this fee, they would be sent something in the mail pursuant to the ordinance that they were required to pay within a certain amount of time? Is that happen under the ordinance?
I'm not sure as a practical matter how they come to pay the fee, but it is a fee that would be required by the ordinance for a new development at the time. But again, we didn't reach that ordinance because this was a bargain for arrangement.
Just trying to see how it was different under the ordinance in a different setting versus the contract setting.
Well, again, Your Honor, because
Would they have,
in the ordinance setting, you're looking at our authority under the public enterprise statutes, which then quality built homes comes into play. Under the contract setting, you're looking at it under 168-320 and 168-312.
but if you're looking at the ordinance pre-quality homes, and you're looking at this contract, you're looking at this bargain, before the first quality homes decision, wouldn't the developer be like, well, I might as well agree to that because the ordinance requires it. I'm not really giving anything. It's just doing it in a different way.
As a practical matter, that's possible, but again, when we're looking at the four corners of the agreement, not what their motivation might have
Right.
been to sign this.
Right. Okay.
And when you look at the four corners of the agreement, you see, okay, they've agreed to do A, B, C, one of which is pay these fees, and in exchange for that, they get, what we agreed to do, which is set forth specifically in the contract. So we're not in the realm of quality built homes because we're not relying on the public enterprise statute. We're relying on the statutes that allow us to contract with developers for expansion of the system and improvements of the system, which we may not have even been able to do under the ordinance because of quality built homes, but we are able to do with a contract because it specifically says in there that we are allowed to contract for improvements, for enlargements. So it's a totally different set of statutes that apply. Our authority does not come from the public enterprise statute, and for that reason alone, quality built homes analysis doesn't apply. You're looking at what is our authority under these other statutes, and our authority under these other statutes is clear that we are allowed to charge for these types of things. So, the argument would just be, well, because it is called a capacity fee, it must be for future services. And that's not what Quality Built Homes said, and that's not consistent with the language in the four corners of the contract. Any other questions, Your Honor?
Well, with regard to the statute of limitations, isn't it for the permitting appeal process?
I'm sorry?
The statute that you're referencing on statute of limitations, the one-year statute, isn't it on permitting appeals?
That's included within that statute, but it's not exclusive to permitting. It's any development, any ordinance that is a land development regulation that is applied to you. And again, we disagree that we applied a land development regulation to them. But under their theory, that this is not part of a contract, we were just applying the ordinance to them. In that case, we are applying a land development regulation to them.
So it really is an alternative argument. It really is an alternative argument.
Yes.
You can't make that argument unless, and you concede in the alternative if they're right. Okay.
Correct. We believe that this is a properly bargained for agreement. They pay the fees. We provide the water sewer system. In their argument, that's not what was bargained for. I think I heard him say this was just some sort of side deal, which, if you're reading the contract, the four corners of the contract, there's no side deals in there. This is all bargained for. This is your obligations and our obligations. It's not like, well, this obligation was just not important. We just kind of threw it in there as a side thing. No, this was a bargain for contract. All obligations of each side were important and bargained for. And under these statutes, we certainly have the right to charge fees for expansion of the system, which is exactly what we did pursuant to the contract. So this is, again, we're not in Quality Built Homes arena because we're not within the public enterprise statutes. And their argument is, well, you can't charge an impact fee under a contract because of Quality Built Homes. But that it kind of falls apart when you analyze why that why that is, because we're not charging, when we charge pursuant to a contract, we're not charging pursuant to the public enterprise statutes. And even if we were charging pursuant to the public enterprise statutes, they're getting immediate services. It's not future services that are guaranteed in exchange for the payment of these fees. They're getting immediate benefit.
But that last argument you're making is much more facts specific, and at least we heard from Mr. Edwards that to construe the pleadings in the light most favorable to the plaintiff, we can't be certain of that.
Well, you construe the light most favorable to the plaintiff, but the contract speaks for itself, and the contract was attached to their complaint, so it is certainly fair game for the court to consider the four corners of the contract. And under the contract, they got immediate services, not future services.
Okay.
I believe I'm out of time unless there's any further questions. Thank you, Your Honors.
Thank you, Judge Inman. I have 3 points I'd like to address on rebuttal. I'm going to take these in an order I did not anticipate, but the first is about the statute of limitations. So initially, I heard Mr. Hartzog argue for 160A-393.1 and the one-year statute of limitations. And then in a second instance, I heard him argue for a 3-year statute of limitations that begins to run at the time the payment is owed. I'd like to start with that second one. That argument appears nowhere in the appellee's brief, and it appeared nowhere in the trial court. That argument has been waived, it's been forfeited, and the court should not address it. The second argument is about 393.1. Judge Zachary, you're exactly right that that statute concerns land development regulations. And contrary to the town's argument, they did not apply a land development regulation here. In the town's code of ordinances, this is a municipal utilities regulation, not a land development regulation. If you look into the statute, it cross-references 160A, 388 subsection B1, which references appeals to a board of adjustment. So it's things like appeals under the Uniform Development Ordinance, appeals of a stormwater permit, appeals of zoning determinations. There's no appellate process, there's no municipal appellate process for an assessment of a fee. In addition, it cross-references section 143-755, and that's where all of these definitions come from. So if the court looks at that statute, it says exactly the type of ordinances this applies to. This is not part of the UDO, which is specifically referenced in 143-755. This is not a stormwater development ordinance. And so it's not any of the ordinances listed in that statute, and therefore it is inappropriate to apply 393.1 or its subsequent recodification to Bill Clark Holmes' claims in this case. The second issue I want to address is this notion that my client contracted to pay fees that, as Judge Zachary asked about, were identical to those that would have been paid pursuant to the capacity fee ordinance. The statute specifically authorizing development agreements in subsection B, that's 160A 400.20 sub B, says that the town cannot contract for an illegal or unlawful tax or fee. We are still a Dillon's Rule state, and the town is still constrained by the powers given to it by the legislature. The legislature did not give the town the power to contract for future potential services in relation to its water and sewer system. Yes, the town can contract to expand it, but that's not what it did here. It charged Bill Clark Holmes a fee that the ordinance referenced in the development agreement specifically says is to build capital funds for future use. because it used that ordinance to calculate the fee is unlawful under 400.20 sub B. The final point I want to make is that words matter. As I believe Judge Collins got out, the contract probably would have looked different if quality-built homes had been decided prior to entering into the development agreement. But in all instances, the way that the contract is set up now is for future services. We filed a memorandum of additional authorities with the Supreme Court's decision of Town of Spring Hope against Bissett. And that case explains what a current or past service is. The court says that the Town of Spring Hope can charge its municipal water and sewer customers to expand water capacity because they're already receiving water services. You're just charging for you're charging a fee to allow for more capacity. In this case, it is quite literally future services if the fees are paid in advance of the work. And that goes back, Judge Inman, to your point that we don't know where the construction was on this record. We don't know when the town started constructing the Sunset Lake Road waterline expansion. And if those fees were paid in advance of that construction, that is a fee for services to be furnished, and it is unlawful under quality-built homes. I said I had 3 points. I want to clarify a question you asked, Judge Inman, and that is, I believe my concession was that my client would not seek, under quality-built homes, my client would not have a claim for a refund if the fees were for past services. I don't know that I've analyzed or am prepared to argue that specific aspect of the potential claim today. And unless the court has any more questions, which I'm happy to answer, I'll yield my time.
So just so that I'm sure, ultimately your argument, if we go back to what you just last said, depends upon when the construction happened. Is that correct? If the construction happened and then you all paid the fee, then it was okay. If you all had the fee and then the construction happened, then it wasn't.
I think that's I want to make sure I don't concede too much. If my client paid the fee and the fee was for construction that was to happen, yes, that's correct. It depends on when the construction started. And again, going back to our earlier colloquy about Section 3 of the agreement, it's unclear when that construction began.
Thank you very much for your arguments. The case is submitted. We're going to adjourn and then come back for a ceremonial session to administer the oath to some new lawyers.
All rise. This session of the North Carolina Court of Appeals is adjourned.